The senior courthouse bailiff at the side door of courtroom 8 that Thursday morning, a wide-shouldered man named Aurelio Vidal who had stood post in the federal building for 23 years, and who had in those years watched many kinds of defendants walk through many kinds of doors, was the first person in the building to see the live stream. He saw it on his phone in the small bailiff's alcove off the corridor during the morning recess. He had not gone looking for it. The notification had popped up on the secondary phone the marshal's office issued every bailiff for monitoring open-source threats to in-progress federal proceedings. The notification said only, "Target defendant, live now." Aurelio Vidal tapped it. What the secondary phone showed him was a clean, very brightly lit, vertically framed shot of the defendant in the trial Aurelio had just escorted back to his client conference room. The defendant, a 36-year-old lifestyle and investing influencer named Dax Holloway, was standing in the client conference room with his phone propped against a stack of his own paperback books on the table. He was speaking in the practiced loud but intimate voice he had built a 4 million follower audience on directly into the camera. The text overlay along the bottom of the screen read in red sans serif, "Back from recess, the old man bench is losing it." The comment column on the right was running too fast to read. The microphone was picking up clean audio. The audio was saying, "And I'm telling you right now, this old school bench won't catch it. They don't even know what an LLC is. By Friday I'll be in Lisbon, hit the bell, hit it, drop a heart, let's go." Aurelio Vidal stood in the bailiff's alcove and held the phone for a long, careful second. Then he did 3 things in order, the way the bailiff's manual instructed and the way 23 years of standing post had taught him. He screen-recorded the live stream on the secondary phone. He walked, at a pace that did not draw attention, to the clerk's small office 2 doors down. He handed the secondary phone to the clerk of court, a calm, methodical woman named Imani, and said very quietly, "Get this to Chambers before recess ends. Mark it as time of day and source verified. I have the original." Then he turned and walked back to his post and stood, exactly the way he had been standing 5 minutes earlier at the side door of courtroom 8. Recess was scheduled to end at 11:05. By 11:02, Judge Ruben Bellamy had been informed. Judge Bellamy had been on the federal bench for 9 years. He was 67. He had practiced commercial securities litigation for the 28 years before that, had taught complex financial instruments to 2 graduating classes of clerks at a regional law school, and had a phrase that his courtroom regulars knew by heart. The phrase was, "This bench has read the prospectus." Judge Bellamy had in fact read the prospectus. He had also, before he had ever come to the bench, watched the early days of the social media platform Dax Holloway had built his audience on. He had not, contrary to the assumption Dax Holloway had just delivered to 4 million live viewers, ever once in his 9 years on the bench failed to understand the technology the defendants in his courtroom thought he did not understand. The technology was the easy part. The harder part, the part the bench had spent 40 years learning, was knowing what to do with what it showed you. The case in front of courtroom 8 that morning was United States v. Holloway. Dax Holloway was on trial on a 5-count federal indictment for securities fraud, wire fraud, and criminal tax evasion, in connection with what the government had characterized as a $180 million follower-funded investment course scheme that had over 4 years sold tiered access to what Holloway had marketed as a proprietary trading methodology. The methodology, the indictment alleged, did not exist. What had existed was a system in which a portion of every new follower's course payment was paid out as the trading returns of the previous round of followers, while Holloway himself had, in the same 4 years, moved approximately $52 million of the proceeds into a network of personal LLCs, a single luxury condominium in another country, an 86-foot motor yacht registered to a third country, and a particular cryptocurrency wallet the prosecution had described. In the indictment, as the defendant's exit account. The trial had been in its 3rd week. The prosecution had rested 2 days earlier. The defense had opened its case the previous morning. Judge Bellamy had granted a 15-minute mid-morning recess at 10:50. He had returned to chambers, taken off his robe, drunk a glass of water, eaten a single dry tea biscuit from the tin his clerk kept on the windowsill, and read 3 pages of an estate tax opinion he was drafting in a separate matter. At 11:02 his senior law clerk, a steady young man named Ethan, had knocked on the chamber door and brought him the screen recording from Imani the clerk and a 1-paragraph written summary that Imani had handwritten on a sheet from her own desk pad. Judge Bellamy had watched the live stream once at half speed. He had read the time stamps. He had read Imani's handwritten summary. He had looked at Ethan and said evenly, "Tell Imani I want this admitted as a court exhibit before lunch." Tell the courtroom deputy to bring the defendant in 5 minutes early. Tell counsel I want both of them at sidebar the minute the defendant is at the table. Thank you, Ethan. Ethan had said, "Yes, Your Honor," and gone. At 11:06 the courtroom resumed. Dax Holloway, returned from the client conference room by Aurelio Vidal himself, sat down at the defense table next to his lead attorney with the small private half-smile of a man who believed he had just spent a productive recess. His lead attorney, a competent and overworked partner named Greta Lindstrom, did not see the half-smile because she was reviewing her notes. Judge Bellamy entered. The court rose. The court sat. "Counsel," Judge Bellamy said, "approach." Greta Lindstrom approached. The lead prosecutor, a careful assistant U.S. attorney named Mitchell Cho, approached. They reached the sidebar. Judge Bellamy did not raise his voice. The two attorneys leaned in. "Counsel," Judge Bellamy said, "a matter has been brought to the court's attention. During the morning recess, the defendant conducted a public livestream from the client conference room. The livestream contains statements directly relevant to the defendant's intent, his understanding of these proceedings, and his stated plan to leave the country before Friday. The livestream has been screen-recorded by the courthouse bailiff at the time of broadcast, has been authenticated as to time and source by the clerk of court, and will be admitted as Court's Exhibit 1 in this proceeding. The court intends to address this matter directly on the record in approximately 3 minutes. Ms. Lindstrom, I'm giving you a brief opportunity to speak with your client before the court proceeds. I'm also giving you fair notice that the court intends, at the conclusion of that on-the-record colloquy, to act under its summary contempt authority and to entertain the government's motion to revoke the defendant's pretrial release. Mr. Cho, have you, as of this morning, prepared such a motion?" Mitchell Cho said, "Your Honor, the government is prepared to make that motion orally on the record at the court's convenience." Ms. Lindstrom, 3 minutes. Greta Lindstrom returned to the defense table. She leaned in to Dax Holloway. Whatever she said to him, she said in a low voice that Aurelio Vidal at his post by the side door could not hear. He did not need to hear it. He saw Dax Holloway's half-smile fade by inches across the 3 minutes Ms. Lindstrom spoke to him. He saw the defendant's right hand, on the table, tighten very slowly around the cap of his pen. He saw Dax Holloway at the end of the 3 minutes take his phone out of his pocket, look at the screen, see what had to be a comment column running on his livestream that he could no longer manage from inside a courtroom, and place the phone face down on the table. He saw Dax Holloway look, for the first time that morning, at Judge Bellamy. "Court will be in order," Judge Bellamy said. "Mr. Holloway, please rise." Dax Holloway rose. Greta Lindstrom rose beside him. "Mr. Holloway," Judge Bellamy said, "during the morning recess of these proceedings you conducted a public livestream from the client conference room of this courthouse. The livestream has been authenticated and will be admitted as Court's Exhibit 1. The court will, on the record, play the relevant portion of the exhibit now. Madam Clerk." Imani the clerk played the screen recording. The courtroom heard the loud but intimate voice from the morning recess speak the words, "This old-school bench won't catch it." It heard the words, "They don't even know what an LLC is." It heard the words, "By Friday I'll be in Lisbon." The audio was clean. The audio was unmistakable. The text overlay along the bottom of the screen was time-stamped to 10:53 of that very morning. Imani stopped the recording. The courtroom was very quiet. Judge Bellamy folded his hands. "Mr. Holloway," Judge Bellamy said, 3 observations. The first, this bench has read the prospectus. This bench has, in fact, read every filing your enterprise has made with the federal securities regulator in the last 4 years, including the 3 you withdrew under threat of regulatory action in 2023. This bench knows what an LLC is. This bench knows the names of every one of the 17 LLCs into which your $52 million of follower funds were moved between 2020 and 2023. This bench also knows the cryptocurrency wallet you have, in your livestream this morning, just publicly described as your exit account. The second observation, your statement that by Friday I'll be in Lisbon, is a direct contradiction of the sworn representations on which the magistrate granted your pretrial release at your initial appearance 14 months ago. The magistrate accepted your sworn representation that you would not leave the federal district. You have, in this proceeding, just publicly announced your intent to do exactly that. The court considers your statement to be evidence both of consciousness of guilt and of imminent flight risk. The third observation, your livestream this morning, conducted in a federal client conference room during the recess of an active federal jury trial, in which you publicly mocked this bench, signaled to a 4 million follower audience that the proceedings against you are an inconvenience you intend to outrun, and invited an unverifiable number of those followers to participate in your exit by purchasing a follow-up product you described as a masterclass on staying free, is a direct, willful, and contemptuous violation of the standing trial conduct order issued at the start of these proceedings. The order, signed by you and by Ms. Lindstrom on the 11th of last month, expressly forbade any public statement by you regarding the proceedings, any social media activity from any device on courthouse premises, and any communication with any audience about your expected outcome. Judge Bellamy lifted his pen. On the record before the court finds you in summary contempt of this court for direct and willful violation of the trial conduct order. The court imposes a contempt sanction of 6 months, to be served consecutive to any sentence imposed on conviction in this matter. The court further finds on the record before it that the statements you made on the live stream this morning constitute new and material evidence of imminent flight risk and consciousness of guilt within the meaning of the Bail Reform Act. On the government's oral motion, the court grants the motion to revoke your pretrial release. Your release is revoked. You will be remanded to the custody of the United States Marshals for the remainder of this trial. The court will, by separate written order, expand the existing asset preservation order in this matter to include the cryptocurrency wallet you have on the record this morning identified by name. The order will be served on the relevant exchange by the close of business today. The court will further refer the conduct of your trial conduct violation, the operation of your platform on courthouse premises during a federal proceeding, and your public marketing of a follow-up masterclass on staying free to the United States Attorney's Office for review under the relevant federal obstruction of justice statute. Ms. Lindstrom, you will not be referred. The record is clear that your client conducted the live stream without your knowledge. It took, from the moment Dax Holloway had said the words old school bench in the client conference room to the moment Judge Bellamy said the words your release is revoked, exactly 19 minutes. Greta Lindstrom did not in that moment try to argue. She had been a good lawyer for 26 years. She had in those years learned that there were moments in which a lawyer's only remaining job was to make sure her client did not in the next 5 seconds make the next 5 years worse. She placed her hand very lightly on Dax Holloway's forearm. Dax Holloway did not in that moment fully understand what had just happened to him. He did, however, understand at least one thing about the woman standing next to him. He stayed quiet. The 2 deputy marshals, Petrova and Sandoval, both of whom Aurelio Vidal had known by name for years, came forward. They did not hurry. They did not raise their voices. They took Dax Holloway gently by the elbows. They walked him through the side door past Aurelio Vidal's post and into the corridor that led down to the holding facility. Dax Holloway did not look at Aurelio Vidal as he passed. He did not, in fact, look at anyone in the courtroom on his way out. He looked at the floor. In the gallery, a man in the 3rd row, a financial reporter from a small business outlet who had been covering the case from day one, sat very still. He had spent 14 months reporting on the rise of Dax Holloway's enterprise. He had, in that time, interviewed 31 of the 842 follower investors the indictment had named. He had, the previous fall, sat in a small kitchen in a small town 2 states away with a retired police dispatcher named Wanda Pesh and her husband Carl, both 73, who had cashed in the larger portion of their retirement account at Dax Holloway's video instruction to buy the dip on a method that had been, in the indictment's later language, a fully invented chart. The reporter did not, in the gallery that morning, smile. He took out his small notebook and wrote, in the margin of an otherwise blank page, the words, "This bench has read the prospectus." He wrote underneath that the time stamp, 11:37 a.m. At 11:38, the courtroom resumed regular trial proceedings. The defense case continued. Greta Lindstrom called 3 of the 4 defense witnesses she had planned to call that day. She did not call her client. The jury did not in the afternoon indicate by any visible sign that they had heard anything about the morning recess. They did not need to. They had been seated in the same courtroom as Court's Exhibit 1 when it was played. They had, like everyone else in the room, heard the audio. By 3 p.m., the federal securities regulator had been served with the expanded asset preservation order. By 4, the relevant cryptocurrency exchange had been served. By 5, the wallet Dax Holloway had described as his exit account had been frozen. The $43 million balance that had been in the wallet at noon was still in the wallet at 5. It would, by sundown, be sitting under court seal alongside the other identified Holloway assets. The receiver who had been appointed in the parallel civil action would, over the following 90 days, begin the long, careful work of returning what could be returned to the 842 follower investors named in the indictment, and to the additional 3,000 or so who had by then been identified by the receiver's own reconciliation work. At 7 that evening, Aurelio Vidal walked his last patrol of the courthouse before the night shift took over. He passed courtroom 8. The lights were off. The bench was clean and empty. The flag stood where it had stood for as long as the building had been a building. He thought on the patrol about the words old school bench. He thought about how those two words had become, over a particular 10-year stretch of his profession, a signal flare that defendants of a certain kind sent to themselves when they were about to make their own case worse. He thought about how the bench had, in his 23 years of standing post, gotten neither old school nor not old school. The bench had stayed exactly what it had always been, which was the bench. The technology around the bench had changed. The arrogance of certain defendants in front of the bench had changed in the directions the technology allowed. The bench had not. He thought also about Wanda and Carl Pesch, whom he had not met but whom the reporter in the third row had written about in the small business outlet's coverage 3 months before. He thought about the 842 follower investors named in the indictment. He thought about how the receiver's work would, over the next year, return what it could, and how what it could would not, by any honest measure, be all of what had been taken. He thought about how a federal bench could not, at the end of any proceeding, undo. He thought about how the bench's job had never been to undo. The bench's job had been to do, lawfully, what could now be done, in the order it could now be done on the record, with the patience the building had been built for. The bench had done that today. He had been able to help at one small moment in the morning, by tapping a notification on the secondary phone and walking at a pace that did not draw attention to the clerk's office. He thought about how the building ran on small moments like that. It always had, it always would. The next morning, the financial reporter from the small business outlet filed an 1,800-word piece that ran on the outlet's home page for the rest of the day. The piece carried a single photograph, a stock image of an empty federal courtroom, and quoted exactly 2 sentences from Judge Bellamy's ruling. The first sentence was, "This bench has read the prospectus." The second was, "The order will be served on the relevant exchange by the close of business today." The piece quoted in addition 3 of the 842 follower investors, including Wanda Pesch, who had agreed when the reporter had called her to be quoted by name. Wanda Pesch had said only one thing the reporter had used in the piece. She had said, "He said we didn't read. I read every word of it. I just didn't know what the words meant. I do now." By the end of the following week, the trial had concluded. The jury had returned guilty verdicts on 4 of the 5 counts. The 5th count had been resolved by a stipulated dismissal as duplicative. Sentencing had been set for the spring. Dax Holloway would, between conviction and sentencing, spend his nights in federal pretrial custody. He would, in the 4-month interval, not livestream anywhere. He would, in the same interval, dictate to the small federal correspondence form. He was permitted a single letter to Greta Lindstrom asking her to convey to the court that he understood now what the trial conduct order had been for. Greta Lindstrom would forward the letter through proper channels. The court would read it. The court would not, in the spring, mention it from the bench. The court would impose, with measured care, a sentence within the guideline range, plus the 6-month consecutive contempt sanction Judge Bellamy had pronounced on the Thursday morning that had become the morning the trial had turned. In the corridor of courtroom 8 that Thursday evening, after the building had emptied, Aurelio Vidal walked his usual slow route past the empty bench and the empty defense table and the empty gallery. He paused for one short second at the side door he had stood post at that morning. He set his hand on the wood, the way he had set it down 1,000 times in a career, and felt the small worn place at hand height where 23 years of his own gloves had polished the grain just slightly. He thought about how a building gets to look after enough years like the people who have kept it. He thought about how, on the right kind of day, the people in it got to look briefly like the building. The bench had been the bench. The clerk had been the clerk. The bailiff had been the bailiff. The lawyers had been the lawyers. The record had carried it all forward. The record would carry it forward, beyond this morning and beyond this trial, into the slow, patient, careful follow-on work that the receiver and the regulator and the United States Attorney's Office would now do in the order they would do it. Aurelio Vidal turned off the corridor light. He walked out into the cool evening. He went home. He slept well. In the morning he came back. The building, in its quiet and lawful way, was waiting.